I don't want you to sit in a room where everyone's constantly flipping the page over and makes a lot of noise.
Would you recommend the sheet to be more like equation? Or would you
My
provide?
recommendation is you want to be in a situation where you actually don't need a cheat sheet. So what I usually did as a student was to write up 12, 13, 14 cheat sheets, put them on my wall, and look through them on my wall. And in the end of the study period, I really didn't need a cheat sheet. If in the end, the day before the exam, you realize there's this one concept that I always forget about on my 13, 14 cheat sheets on the wall, put that on your wall side. Right? But ideally, if you do it, I don't think you need a cheat sheet.
I'm really confused. N's the last mover, right? So we start with her chaos.
Yes.
And so in this case she wants 5, and in this case she wants 2.
Yes, exactly. So N would accept the offer to lunch. 5 is greater than 3, and 2 is greater than 1.
And then when Bert looks at those, you compare 3 and 2.
Yes.
And then do you compare these ones here?
And then you know that N compares this 5 here to this 4. Right? N knows Bert will offer lunch if she refuses, and she knows she will accept lunch.
Okay.
Right? So she knows she's going to end up, if she refuses, she's going to end up with 5. If she cleans, she's going to end up with only 4.
So then that's the...
That's where they're going to end up. Right? Cool.
So I was just wondering, because I've like not taken it any of the econ courses yet. I'm taking it for
Let's go sit outside so they can start their class.
Oh, sorry, you which? What are you looking for?
The lost property.
Oh, lost property.
Because I lost a calculator. Oh, it's these. Yeah.
Both of
Thank you
those?
so much,
Okay.
yeah.
Oh, good.
Okay, everyone, let's get finished with mistake today. That's what we're going to do. I'm going to finish looking at how the courts have interpreted the mistakes legislation, and we'll see that ever since Conlon and Oslands, they were quite keen in that case to include as much as possible within the ambit of the Act. And then since then we've seen the courts trying to narrow that ambit, and finally after Watson and Zhao we see quite a few hurdles being placed in the way of a party successfully arguing relief under the mistakes legislation. So you saw Conlon and Oslands, the courts allowed what was in effect a purely unilateral mistake, which was unknown to the other party, to be grounds for relief under 241A3. And then in Poulger and Butland, the same Court of Appeal a few years later saying, no, that's not the case. A purely unilateral mistake unknown to the other party is not Section 241A3. That would include all mistakes made by one party only. The only way you can get under a unilateral mistake is 241A1, and that requires knowledge of the mistake by the other party. Furthermore, in Poulger, the party arguing mistake came up against the problem that the mistake that they argued was the effect of their written agreement. They misinterpreted, the court said, what they had actually said in their letter. And that under Section 25 is not a qualifying mistake for the purposes of the Act. And then we had TriStar, which said a number of things. Firstly, the High Court had allowed that there was a mistake in TriStar which resulted in a substantially disproportionate exchange of values when the difference was the GST component. So TriStar was overturned, the High Court judgment was overturned by the Court of Appeal on different grounds, so they didn't touch that part of the finding. So, at least according to the High Court in TriStar, a difference in 12.5% is enough to trigger that 241C, disproportionate exchange in value. The Court of Appeal, though, also overturned the High Court on the grounds that the unilateral mistake under 241A1 requires actual knowledge by the other party. The other party has to actually know that the first party is mistaken when they're entering into the contract. It is not enough, as the High Court had held, that that knowledge be constructive or should have known. That's not the standard. The standard is actual knowledge. And so that standard of actual knowledge has to be proven on the balance of probabilities. How you do that may include saying that a reasonable person would have been aware of the mistake, and therefore this person, this party, this other party was aware, despite their arguments to the contrary. So you can use the same evidence to argue constructive knowledge and actual knowledge, but the point is you're using it to prove that they actually knew, not just that they should have known. It is a higher threshold to argue a unilateral mistake under 241A1. TriStar also held, because in the alternative, the party arguing mistake also argued for rectification of the document. This failed, firstly because there was no common mistake. Secondly, and therefore no common continuing intention up until the time that the contract was executed. But secondly, even if it was a unilateral mistake, and that was unknown to the other party, and so therefore doesn't have the same situation as we saw in A. Roberts. But furthermore, the Court of Appeal said unilateral mistakes, like we saw in A. Roberts, cannot be grounds for relief. Cannot be grounds for rectification after the passing of the mistakes legislation. Essentially because the court said any such mistakes are covered by Section 241A1, and if you allow rectification, you effectively do away with Section 241A1 entirely. It would become OTOs. Now, I think that reasoning is wrong for a number of reasons. Essentially, that there are situations where 241A1 would apply where rectification would not. The most obvious being when the contract is oral and not written, because of course rectification only applies to written agreements. Furthermore, it seems that the saving provision in the Act, which is now contained in Section 22, where it says that nothing in this subpart affects the law relating to the rectification of contracts, that doesn't suggest any narrowing of what the law relating to rectification consists of. This suggests that it was taking in the entire law of rectification as it stood when the mistakes legislation was passed. So I think there's a good argument to be made that the Court of Appeal in TriStar on the rectification point was wrong, and that the passing of the mistakes legislation does not do away with the ability to argue rectification for unilateral mistake. And I think certainly Burrows, Finn and Todd would, I think, agree on that point. So the textbook writers would agree. The question is, would a court agree? It hasn't been decided since TriStar. So there's a real question mark over the ability to argue rectification when the mistake is unilateral. So that's the situation we saw in A. Roberts. Obviously, rectification can still be argued when the mistake is a common one, or there's a continuing common intention up until the time that the contract was entered into, just like in Dundee Farms Limited. But unilateral mistakes not clear after TriStar. Okay, that's the summary of where we're at before we get on to Watson. I want to do Watson, which is the latest Court of Appeal judgment from last year around the mistakes legislation. And then I would like to go through a problem question together that will hopefully tie some of this up. But before we get there, are there any questions at all about the mistakes legislation or how it's been applied by the courts? Great, okay. Well, let's get on to Watson and Zhao. Like so much of New Zealand's negligence and contract law over the last 20 or 30 years, this was a dispute arising from a leaky house. There was the sale and purchase of a residential property which very quickly developed quite severe leaky issues. And the purchasers sought to claim damages or get some monetary relief from the vendors based on the value of the property with the leaks, as opposed to the value of the property it would have had without the leaks. And they argued breach of warranty, they argued misrepresentation, and for our purposes, most importantly, they argued mistake. And at the High Court, it was accepted that there was a common mistake made by the parties. That is a Section 241A2 example, where all the parties to the contract were influenced in their respective decisions to enter into the contract by the same mistake. And that same mistake was that both parties thought that the house was sound. So the High Court said, yes, that was a common mistake, which entitled the purchaser to relief under the Act. And the High Court said, we will award an amount of damages equal to 70% of the difference in value of the property with the leaks as opposed to without the leaks. And the reason they didn't give 100%, or the reason the High Court didn't give the 100% of the difference, was that it held that at least some of the cause of the mistake was due to the purchaser's own fault, that the purchaser should have been more onto it, should have got their own building report or inspection, etc. So it was partly the purchaser's fault, so we're going to reduce the amount of damages they can get by 30%. The vendors appealed to the Court of Appeal. And the Court of Appeal overturned the High Court judgment. And it did so for a number of interlocking reasons. The first being was that they started, and this is very interesting, and compare it with Conlon and Oslin's, where this section didn't even get a look in. They started with section 21(2)(b). Remember, that's the section that starts off the entire mistakes legislation, and it says the powers to grant relief by the court, so the powers to grant relief under this Act, should not be exercised in a way that prejudices the general security of contractual relationships. And that's where the court started from. And the court says that it's not just about whether or not it goes against the terms of this particular contract, or if it undermines the security that parties should be able to place on this particular written contract. But more generally, you need to look at the general nature of contracts of this type. And would a finding that there's been a mistake and a granting of relief for a mistake for this type of contract, would that undermine the security that other parties should be able to place on these types of contracts? And what is this type of contract? Well, it's only one of the most influential and important types of contract for most of New Zealand, the standard form sale and purchase agreement for residential property. The Auckland District Law Society Real Estate Institute of New Zealand standard form sale and purchase agreement. These are exceptionally important for most individuals. It's the most important contract they'll ever enter into worth the most amount of money. And it's also extremely important for the New Zealand economy. The entire banking system relies on being able to place faith on the fact that these agreements are enforceable as they are written. They're the basis upon which banks lend money and are given mortgages. And so we should be very wary of exercising our power to grant parties relief from mistakes in these types of contracts. And also we should be wary of upsetting the general allocation of risk in these types of contracts, which is and has always been caveat emptor. That is, when you buy a house, buyer beware. That is, if you're wanting that the buyer should look at the house prior to purchase, should do things like get a building report so that they're satisfied that there are no defects in the property that they are buying. And if necessary, the parties are always free to specifically change the allocation of risk through warranties. For example, they could write in specific warranties whereby the vendor warrants that there is not this defect in question. So, for example, it's common for a vendor to warrant, that is to promise in the agreement, that this house is free from asbestos, for example. That is changing the general assumption of caveat emptor in that particular instance for that particular problem, which is asbestos. But if you don't have a specific warranty, then generally under these types of contracts, the risk is on the purchaser. And that's why it's always a good idea to make conditional offers when you buy a house and make it conditional upon getting a satisfactory building report or a satisfactory moisture report or something like that. Okay, so that's the first starting point. The court should be slow to undermine this. And if we look at the mistake that was alleged, or the mistake that was found by the trial judge, that was framed far too broadly. So if you look at paragraph 51 of the Court of Appeal judgment, there are 5 quotations from the trial judge in which the trial judge sets out what the mistake that he is finding, that they found was. So, what are these mistakes? The physical characteristics and watertightness of the house, that the house was sound and did not leak in any way. As to what were very important physical characteristics of the house, including its general watertightness, that the house was indeed sound and had no significant leaking issues, and that the house was sound and did not have significant leaks. So that's all how the trial judge formulated the mistake that was successful in the High Court. The Court of Appeal says this: in all of these formulations, it is the soundness of the building that is first identified, with leakiness then said to be included within that concept. The pleaded mistake in the amended statement of claim was that the property did not leak and/or was a sound one, with no likelihood of weathertight problems. The judge found that the purchasers wanted and thought they were getting a sound home. The problem for the Court of Appeal is that to frame the mistake in that way is far too broad, because any defects in the property, including weather tightness, would be caught under this definition of mistake, which would mean that caveat emptor goes completely out the window, because any defect which is unknown to both parties would, according to the trial judge, be a mistake for the purposes of section 241A2, a common mistake. They both thought they were buying and selling a sound home, and it turns out they weren't. So any underlying problem with the house would be caught, which is far too broad and would undermine the general position of caveat emptor, which is especially relevant for this type of contract. The reason it was discussed, or it was framed broadly, the reason the trial judge didn't say that the mistake was one specifically as to whether or not the house leaked or not, was that as a finding of fact, the trial judge said that there was no discussion between the parties about weather tightness or leakiness. There was no evidence that either party had turned their minds to the question of leakiness. It was not directly considered by either party. So at most, all you could say is they thought that they were buying and selling a sound home. But if that's a qualifying mistake, then, as I say, any defect in the house would be caught under the mistakes legislation, which is far too broad and undermines caveat emptor. But also, the fact that they didn't turn their mind or consider leakiness in particular is a problem when you're trying to argue mistake, because look at the wording of section 241A2. Except you can't because it's too small. All the parties to the contract have to have been influenced in their respective decisions to enter into the contract by the same mistake. Well, the Court of Appeal says you cannot be influenced by a mistake if you haven't turned your mind to the question or to the defect in question. The most that could be said was that the parties hadn't thought about it at all. Well, if that's the case, you can't be influenced about something you're not thinking about. According to the Court of Appeal, to be influenced to enter into a contract by a mistake requires you to have thought about the thing or the subject matter or the quality that you are arguing you were mistaken about. The parties would have had to turn their mind to the fact, to whether or not the house leaked, and they would have had to have said, no, there is no problem with leakiness. Because only then could you say that they were actually mistaken about the leakiness in particular, and only then could you say that that mistake as to leakiness actually influenced their decision to enter into the contract. So being unaware of something and not turning your mind to it as a possibility means that you can't plead mistake, because you'll see that each of the relevant mistakes requires this influenced to enter into the decision, to enter into the contract. So if you don't turn your mind to something, you can't be influenced by your mistaken belief about that thing. So for all these reasons, the court said there is no qualifying mistake. The alleged mistake, as pleaded, was far too broad. You need to show that there was a particular defect in the property, that both parties, well, for 241A2, that both parties had thought about and had got wrong, they were mistaken about it, and therefore they were influenced to enter into their decision in order to try and argue qualifying mistake. But even then, even if you show that the mistake was more particular and the parties had turned their mind to it, you will still run up against the problem, which wasn't even considered in this case, that 241C would prevent you as the purchaser from arguing that the mistake was one you should get relief for, because these types of contracts, these sale and purchase agreements of residential property contracts, place the risk of mistake upon the purchaser. And that means that they are unable to argue mistake. So essentially what Watson and Zhao is saying is either you need to write into the contract a vendor's warranty about the defect in question, but if you haven't turned your mind to the defect, it's going to be hard for you to then ask for it to be put into the contract. Or you need to ask the vendor's whether or not this house has this defect. And if they incorrectly say it doesn't, then you get them probably not because there's a mistake, but because they have misrepresented the quality of the house. Is this a leaky house? And they will say no, and either they're lying because they know it's leaky and they don't want to say it, or they don't know it's leaky, in which case they're innocently misrepresenting. In which case you can get damages as if that was a term of the contract which they had breached. In this case, that's what the purchasers alleged happened, and the trial judge found that that wasn't the case. They said no such conversation as to leakiness took place. But if there's no conversation as to leakiness, you can't argue misrep, but also you can't give evidence then that you were influenced to enter into the contract by the mistake you made as to leakiness. You can see in Watson and Zhao a much more reticent Court of Appeal. They really are concerned about too readily finding mistakes. When you've got a written contract, we're not going to too readily overturn that or grant relief to one party because we've got to keep in mind the general security of contractual relationships, and particularly when that general type of contract is the sale and purchase of property, as it was here. Real property, real estate, homes. Right, any questions at all about Watson? Does it make sense? Good? Okay, fantastic. Well, if that's the case, let's use this time to do this question I gave to you, bless you, from earlier. It's an early exam question from 2017. It's a relatively short question, and I think you had about 25 minutes to answer it, if I remember correctly. So what I want you guys to do is read it for 5 minutes, make some notes, talk to the person next to you if you want, about how you go about answering this, and then I want us to come together and try and analyse it together. Okay? Go to it, 5 minutes. Feel free to talk to your neighbour about it if you wish. If you're making a plan for this question, I would not be spending more than 5 minutes in the exam doing that. I'd also recommend making a diagram. One more minute. Okay, so this is a rewrite of a case called Tamplin and James, which we used to teach in formation, which stands for the proposition that when you go to an auction and you buy and you bid on something, you're bound to what the property is, not what you think the property is. But this is slightly different. So what you have is an inn which owns a field beside it, or comes with a field. And the vendor intends to sell the inn in the field. The purchaser intends or thinks he's buying the inn and the yard. And it turns out that the property description is actually just the inn. The contract itself is an oral one whereby Party B says, I'll offer you $600,000 for lot 2, and the other party says, I accept. So, what's the mistake? Who's made a mistake here? And what, if any, of the qualifying circumstances in 24(1)A apply here? How would you go analysing this? Yeah? Well, does the auctioneer just drew it up, right? Who are the actual parties to the agreement?
Both
A and B, great. What mistakes did they make?
B thought that the inn and the yard were for sale.
Yep.
And that's incorrect because the home can't be sold.
Great, yes. Is that the only mistake?
I don't know because A thinks that they're selling the inn in the field, I think, right?
Yes.
Yeah, but that seems correct.
No, because the auctioneer prepares plans and a description of the property which include neither the yard nor the field. So what they're actually buying and selling is lot 2, which is the inn by itself. And both of them have a different mistaken belief about what Lot 2 actually is. So that's, if you're going to get relief, you're going to have to go through section 24, remember. That looks like 24.1a3, where each party is making a different mistake about the same thing. So each party is making a different mistake as to the property described in Lot 2, or what Lot 2 is. Okay, and I think that that's quite a... And you could make some comment that this is different from Conlon and Oslin's, because in that case the purchaser intended the property as it was to buy the property as it was described. Okay, here they're both mistaken. Okay, but that's not the end of the story, right? If we're going to get relief under section 28, we're going to have to go through B and C as well. So B, you're going to have to show that at the time they entered into the contract, the mistakes they made resulted in a substantially unequal exchange of values. So how would you apply that here? What would you say? Yeah. Okay, so what pieces of information he has, but what pieces of information are relevant for determining whether B is satisfied or not? Sorry, 24.1b is satisfied, not party B. What are we comparing? We're comparing the price he paid, which is what? 600, versus what he's getting. So what's he getting? Just the in. So those are the two pieces of information that we need to compare and contrast. Probably not contrast, just compare. Is there a substantially unequal exchange of value? And the question is, what is the value of the in by itself? The objective value, the market value. We don't know what that value is. So what can you say? You'd say you need to compare the value of the in at the time of contract with what he was prepared to pay, what he paid for it, $600,000. Then you need to ask, is that substantially unequal? We don't know what the value of the in is, but the fact that the vendor was prepared to sell the in and the field for 600,000 suggests that 600,000 is probably too high for just the in by itself. But we don't know that. Party A might just have been desperate to sell because it had been passed in at auction. What you would also say is that if, oh sorry, yeah, but remember it wasn't sold because it didn't reach the reserve price. So the vendor, yeah, probably in discussion with the auctioneer, but the reserve price is not an indication of market price. Well, I mean, what is the market price? It's what someone's prepared to buy at auction. But, you know, so the market price, that would be highly relevant information, but it doesn't set the market price. It might be that they just set a really high reserve. What you would also say, though, is in the High Court and TriStar, a difference of 12.5% in the contract price satisfied section 24.1b. So assuming that that is followed, then it shows that the threshold for substantially disproportionate exchange of value, unequal exchange of value, is not that high. Okay? But that's all you can say there. You've identified that that's needed to be satisfied. You've identified what pieces of information the courts will look at. You've identified what you would need to know, the market value of the inn, to determine if that's been satisfied, and you've also identified the relevant authority for the level of disproportion that would satisfy it. Okay? So you can't provide an answer, but you can at least discuss it. And then finally, you would also need to show that C is satisfied. This is interesting. Firstly, what's interesting is that we're not told here who is seeking relief. We don't know who's trying to get out of this contract. Or if anyone's trying to get out of it, maybe they're both happy. We've just been told to analyse these facts. But you would make the point that under C, the party seeking relief can't have been the one whom the contract places the risk of the mistake in question on. Now, the contract itself is an oral one, doesn't have any express clauses, and arguably, by implication, neither party is taking the risk of mistake as to the description of the property on themselves. Neither of them is saying, I'm going to offer to buy or offer to sell lot 2, whatever it is. It's arguable. I don't know. I think maybe you could argue B implicitly took the risk of mistake. But I don't think you can come to a firm conclusion there either. Good answers would have discussed section 23 subsection 4 as well. There is a good argument to say that there is no contract concluded here, right? That both parties are at cross purposes. It's kind of like Raffles and Wickelhaus. And there could be an argument that actually no contract was formed, there was no ad item, no consensus ad item. But you would say, under 23 subsection 4, you assume that there is a contract and then go ahead and see whether relief should be granted. Yeah, sure.
So then, if we were to write this in the example, we look at section 23 first, whether there's a contract rather than at the end, or does it really matter?
Yeah, no, that's a good question. I haven't really been going through it in order. You'd probably want to do it first as like a preliminary matter. But even if you put it at the end, you could say, by the way, I've assumed there's a contract for the purposes of this answer because section 23(4) says I can do that. Yeah, so yeah, structure is important. So I'm not thinking about the structure now, but you could probably do either there. Okay, section 25 is not relevant here. There's no mistake as to the interpretation of the contract because, well, there's no written contract for a start. Both parties are intending to buy and sell lot 2. It's just what lot 2 consists of, or the quality of lot 2. Section 27 is relevant. Again, we don't know who's asking for relief, but any relief granted, the court must take into account the extent to which the party seeking relief is responsible for the mistake. So here party B is quite clearly at least partly responsible for the situation he finds himself in. He assumed he knew what lot 2 consisted of and he didn't check it. And if he had, he would have realised he was mistaken. So if party B is seeking relief, then the fact that he in large part caused this mistake is relevant. Arguably, A is also a cause of this mistake by not checking lot 2 himself, assuming that it included the yard when the auctioneer drew it up incorrectly, or perhaps by not giving clear instructions to the auctioneer. This, I think, is less culpable than B, because A can always turn around and say, assuming he gave clear instructions, I gave clear instructions to the auctioneer, it's the auctioneer's fault, I'm entitled to rely on the expertise of the auctioneer to draw it up correctly, I shouldn't have to check it all the time, I'm not an expert, etc., etc. But that is relevant, you need to identify it's relevant. And then finally, the nature of the relief. You need to say, look, under Section 28, neither party has any right to anything. That the courts are trying to give relief to do justice between the parties, taking into account their respective culpability for this mistake. And the court can fashion any relief it sees fit. Now, a good answer would recognise that B is not going to get what he thought he was getting. The court cannot order the contract to be amended to give B the yard, because, of course, the yard is not there to sell. It's not the owner of the inns to sell. I think there's probably two options here. One, the court enforces the agreement to be what Party A thought it was, that is the sale of the inn and the field. That at least was a price that A was prepared to accept. On the other hand, that might be, what might be relevant is how much the inn and the field is actually worth. It might not actually be worth $600,000. It might be a really good deal for A. So the other option, which might actually be the most likely, is that the court just says there is no we are not going to enforce any contract whatsoever. You're both free to walk away and start again, maybe go to auction again or something like that. Because maybe Party B just does not want the field. Okay, but again, you can't come to any conclusion. You just need to identify some of the options and the fact that the court can do whatever it wants to do justice in this particular case. Make sense? Happy? Thanks. Great. Okay. Well, if you are, that's great, because we've finished mistake. We are going to look at our last topic starting on Monday, which is terms. So we're going to look at incorporation of terms, implication and interpretation, 3 I's. So we'll start that on Monday. Please seriously start getting your notes and stuff in order. It's not long until the exam. Well, it's about a month, but you know. You don't want to be leaving it to the last minute. Remember my office hours, I'm always free to discuss anything you don't understand. I'm always free to discuss after class as well. But otherwise, have a fantastic rest of the week, and I'll see you on Monday.